This Honorable Court of Criminal Appeals of Tennessee is now in session.
Good afternoon. Welcome to the Court of Criminal Appeals, East Tennessee Division in Knoxville. The panel for the argument is well, it would be to my right if Judge Robert Holloway from Columbia, and to my left, Judge Robert Montgomery from Kingsport. I am Kerwood Witt from Monroe County. Call the case, Mr. Clerk.
State of Tennessee versus Vanessa Hurst.
Thank you. Arguments will be, there we are, 20 minutes aside. If you're arguing for the appellant, you can reserve a portion of your 20 minutes by making an announcement and telling the court that at the beginning of your argument. So you can proceed with your argument, Mr. Webb.
Thank you, Your Honor. My name is Timothy Webb here for the appellant, Vanessa Hurst. I would like to reserve 2 minutes at the outset for any rebuttal, please.
Go ahead.
Thank you. What we're here on today, the appellant would state that the trial court erred in denying the suppression of some statements that were obtained as a result of an illegal search and seizure of her person. Late on the night of November 27th, 2015, the appellant had reported an attempted rape on her person. Now, the officers who came to investigate at that time spoke with her and another person who was present and determined that nothing at that time, to their knowledge, had happened. And they transported Miss Hurst and the person who was there to a house across the state line into the Commonwealth of Kentucky. Now, upon the officer's return to the state of Tennessee, he received a call that there was a person in a yard there in Claiborne County, Tennessee. He returned to that scene, or he went to that scene. They located the body of the deceased there. And while they were investigating, one of the officers that was there directed that officer, Officer Blake Laws, to go back and get Vanessa Hurst from where she had been dropped off. As I stated, this was across the state line in Kentucky. So Officer Laws departed from the scene, went back across the state line, ordered Miss Hurst into her car. She was transported back to Claiborne County, Tennessee, where she remained in the back of a locked police car for a couple of hours until they took her to the Claiborne County the Clairfield Fire Department for further interrogation. Now, the state concedes that Miss Hurst was picked up across the state line. The state concedes that this was an interrogation. Now, the trial court was requested to suppress those statements that Ms. Hurst had made as a result of that. Now, during the suppression hearing, Officer Henniger testified that he had been dispatched to investigate this original sexual assault very, very late in the evening. Sergeant Henniger testified that he did not believe the allegations that were made by Ms. Hurst, sent Officer Laws back with the defendant across the state line into Kentucky. So Officer Henniger was at the scene of where the body was and directed Officer Laws to go back and get her. Now, the testimony at the suppression hearing shows that she was placed in the back of a locked police car. She was driven across the state line into Tennessee. She remained in the back of that police car for the hours that transpired while they were investigating. She did not get to leave that police car until they were at the Clarefield Fire Department, where she was interrogated on several occasions. Now, after that point, she was taken to the Claiborne County Jail. 3 days later, or 2 days later, an arrest warrant was issued or signed. She remained in custody until she made bond in May of 2016. Now, just a moment, please.
Let me ask you this question.
Yes.
When she was there in Kentucky and they wanted to go to the back to Tennessee to that fire department, did she have any other transportation to get there other than the officer taking her?
I'm not sure I follow the question, Your Honor.
Did she have the means of getting there on her own?
Well, let me make sure I understand this correctly. After they took the initial report of the attempted rape, the officer took her across the line to where she wanted to go.
Yes.
Later, that same officer returned back across the state line to the house where she was, directed her into the car to bring her back. Does that answer your question?
No, my question is, did she have any other means of transportation to get back into Tennessee other than to ride with the officer?
No, Your Honor.
Okay.
She was not given the opportunity or the option to come voluntarily.
All right.
Now, appellate would say that she was unlawfully detained in the back of the police car there. Now, the state conceded that a seizure had occurred at the time Ms. Hurst was placed in the back of that patrol car. Even the court stated that, and I quote here, at some point there is a detention and there is a questioning, but that's okay. Now, it's true that not all intercourse between policemen, deputies, and citizens involve a seizure, but when an officer, by means of physical force, by show of authority, has restrained the liberty of this person, that's when the seizure has occurred. And it just, the test, as the court knows, is whether someone is seized is whether the reasonable person would have believed that he or she is free to walk away. Now, in the suppression hearing, Officer Laws did testify she was placed in the back of his patrol car. Now, he also testified that a person does not have the ability to depart from that patrol car on their own volition. Had she wanted to leave, she could not have gotten out of the back of that patrol car. Now, he did testify that he always places females in the back to keep from allegations being made, and those were his words at the suppression hearing. But in this case, even if arguing that the initial pickup was okay, she remained in the back. He didn't take her and remove her from the back, place her in the front at any time during this seizure. And I would like to reiterate, at the time she was picked up, she was not within the state of Tennessee. She was across the line in the Commonwealth of Kentucky. Now, it is clear without question that her freedom of movement was restrained while she was in the back of that patrol car. Now, whether she was seized or arrested when she was placed in the back of that patrol car, The state did not meet its burden to justify that restraint. The only facts that Sergeant Henniger knew and Officer Laws knew when Sergeant Henniger ordered Officer Laws to go get her was that there was a body in the yard. That's the only thing they knew. No determination had been made at this point as to the cause of death, as to the manner of death in any way. Sergeant Henniger testified that he thought there was a connection. He told Deputy Laws to go get Miss Hurst. And at the moment that that detention started, while we're in the Commonwealth of Kentucky, it continued until the arraignment in criminal court several months, almost 6 months later. It can't be characterized that night as brief. To this day, it cannot be characterized as brief. There was never a change in her custodial status. She was never free to leave police custody from the time she entered it that night. Now, we say that her statement was the fruit of her unlawful detention. Both the Fourth Amendment to the United States Constitution and Article 1, Section 7 of the Tennessee Constitution require the suppression of any statements that come as the fruit of the poisonous tree. Now, the state bears the burden of both justifying that warrantless detention and proving the attenuation of the taint. And in this case, they were not able to do it, and the court erred by allowing those statements to be made or allowed as evidence. Now, there was some discussion during the motion for a new trial about the State versus Brock case. That case held that there was an unlawful arrest when a defendant was secured in the back of a patrol car. They brought him to the police station. Now, a lot of the facts are very, very similar there and in this one. But just a moment, Your Honor. Although the trial court didn't cite it, the Tennessee Supreme Court has held that the following factors apply when determining whether a statement should be suppressed. The presence or absence of Miranda warnings. Now, those did come later on the next morning. Number two, the temporal proximity or the time between the arrest and any statements made, the presence of intervening circumstances, and the purpose and flagrancy of the misconduct. Now, if you look at these facts here for this case, Captain Honeycutt of the Claiborne County Sheriff's Department began interrogating Ms. Hurst around 4:15 in the morning, 2 hours after she was illegally detained, 2 hours after she was seized, 2 hours after she was arrested without a warrant. The second factor is the time period between the illegal detention and her statement. As I said, that interrogation began 2 hours after she was illegally detained. She was kept either inside the back of a locked police car or inside the Clarefield Fire Department. According to Sergeant Henniger, that building only had one door in and one door out. Now, the third factor is the intervening circumstances. There are none here. She was never told she was free to leave. We don't know if she would have been allowed to call anyone once she was detained. As I said, she was picked up across the state line in Kentucky, ordered into the back of a police car, and she came. And the Brock case states that intervening circumstances may in this case, the officers had every opportunity to obtain the permission the assistance of the Kentucky authorities and did not. They just willfully went across the state line to detain, arrest, seize, and bring back Miss Hurst in this case. We would and we state that the statements she gave should be suppressed. We also stated that the evidence is insufficient to support her conviction for either first-degree murder and second-degree murder. And to that end, there was voluminous evidence presented here. Almost none of it applied to Miss Hurst. There was no testimony. There was actually testimony that she had no signs of a scuffle, no blood, no mud, no dirt, no grass stains on any of her clothing. The court actually heard testimony that she had inserted a broom handle inside the anus of the defendant, or excuse me, of the victim, and testimony by the medical examiner stating that there was no trauma whatsoever. We would also state that the evidence is insufficient to support her conviction for second-degree murder here. There was testimony about injuries, other injuries that he had received. It is inconceivable, with the testimony of her clothing and her physical appearance, that she could have kicked the victim and not be covered with blood, with mud, with dirt, with some sort of substance. We would say that the statements as entered that the jury heard did not form a sufficient basis to convict Ms. Hurst of either first-degree murder or second-degree murder, and I would pass to Ms. Orr at this time.
Okay.
Good afternoon, Your Honors. May it please the court, Courtney Orr on behalf of the state. Briefly, at the opening of my argument, I would like to take a couple minutes just to clarify exactly what the record shows with regard to the statements that Ms. Hurst gave to police the night that Mr. Gully's body was discovered. The defendant, in her motion to suppress, claimed that she gave 4 statements to the police that in that 24-hour period. It's not exactly clear to me where the 4 statements come from, but it is we have testimony and evidence about 2 statements that she gave to police. One, which was the subject of the suppression hearing, in which counsel has argued extensively about in his brief and at the arguments here today, were given to Sergeant Henniger and Captain Honeycutt at the fire department at 4 a.m. on the morning of November 27th. That statement was not introduced at trial. Instead, the only statement that was introduced at trial was a statement that the defendant gave to Bradley Duncan at 5:30 p.m. on November 27th. Although the defendant in her brief and here today claim that she was in custody continuously from around 2 a.m. on November 27th until she gave her statement, presumably at 5:30 p.m., there's nothing in the record to support that she was still in custody, and I will note that statements of counsel are not evidence. The only evidence that was submitted in the record regarding what happened after the 4 a.m. statement was that Sergeant Henniger testified at the suppression hearing that he was there for part of the 4 a.m. statement and that he believed he left before the defendant finished giving her statement. There's no testimony or no evidence in the record to determine or to show that the defendant was then transported to the jail and continuously remained in custody after she gave her statement at 4 a.m. Instead, the record is simply silent. And I will note, it is the defendant's burden to show that statements are given or the product of a custodial interrogation. And it's only after the defendant proves that a statement is the product of a custodial interrogation, that the burden then shifts to the state to prove compliance with Miranda. But this court need not even get that far in this analysis to affirm the trial court's ruling. Instead, this record is inadequate to review the defendant's suppression claims. We raised this in our brief, but I will note the defendant did not file a reply brief and has not addressed this argument here today. The written motion to suppress is not included in the record. And because there is no written motion to suppress included in the record, we do not know what arguments were advanced for suppression of the 5:30 p.m. statement. And further, because the suppression hearing only addressed the 4 a.m. statement, we do not know what basis the defendant would argue that the 5:30 a.m. statement, or excuse me, the 5:30 p.m. statement should have been suppressed. Without the written motion to suppress, we simply do not know the theory advanced at the trial court to suppress the 5:30 p.m. statement, and therefore this record is inadequate for review of this issue, and this court must presume that the trial court's ruling is correct. Even if this court were to review introduction to the 5:30 p.m. statement, as I alluded to earlier, the defendant has failed to show that the statement to Detective Duncan was the fruit of an illegal arrest. Again, nothing in the record shows that the defendant was continuously in custody from the time that she was picked up in Kentucky until she gave her 5:30 p.m. statement. Instead, the only information we have about that 5:30 p.m. statement is that Sergeant Henniger said that he was there when she gave it, that he wrote it down, he read that statement to her and allowed her to make any corrections, and then that she then signed it, and it's dated and timestamped at 5:30 p.m. There's no proof that the defendant was subject to a custodial interrogation at the time. There's no proof that she remained in custody until that statement was given, and there's simply no proof about the circumstances surrounding that 5:30 p.m. statement, which would allow this court to conduct the analysis the defendant asked for today, which is whether there was enough attenuation from any alleged any alleged illegal arrest in this case. Further, I will note that to the extent that the defendant was arguing that her 4 a.m. statement should have been suppressed and that it was subject to an illegal arrest, it effectively was suppressed despite the trial court's ruling. It was not introduced at trial. The only remedy that would have been available for suppression was exclusion of that statement, and it was excluded. Indeed, I have no idea what her 4 a.m. statement said. So unless this court has any further questions about the issue, we submit the trial court's ruling on the motion to suppress was correct. Next, the defendant, there was sufficient evidence to support the defendant's convictions for both first-degree felony murder and second-degree murder. Starting with first-degree murder, the defendant argues there was no proof that she exercised control over the victim's property. However, the record simply disproves that claim. The defendant had Mr. Gully's keys when she arrived at Mrs. Baird's house. Mrs. Baird's husband gave those keys to the police, and the police used those same keys to start and move Mr. Gully's car. The defendant also told Mrs. Baird that she took Mr. Gully's phone, keys, and wallet. The jury could conclude that Mr. Gully was killed during the perpetration of a robbery, especially in light of the defendant's statement to Mrs. Baird that she, quote, done the final blow to Mr. Gully. Second, the evidence was also sufficient to support the defendant's convictions for second-degree murder. Simply put, the defendant's arguments against this conviction simply amount to an attack of the credibility of the evidence, and the credibility is a question for the jury. This court may not reweigh credibility or the evidence here on appeal. Here, the defendant told Mr. Hurst that Mr. Gully had tried to rape her and that she told him this out of spite so that he would help her beat and kick Mr. Gully. Mr. Gully suffered extensive injuries which caused his death. And based on the evidence submitted, the jury could rationally conclude that the defendant was guilty of second-degree murder. Unless there are any questions, we will rest on our brief for the remaining issues, and we ask that you affirm the judgment of the trial court.
Thank you. We have a minute or so, or a couple of minutes. I'm going to allow you an extra minute because of your freeze frame time a while ago. A couple of minutes, Mr. Webb.
Thank you, Your Honor. In essence, Your Honor, this honorable court. Our position is that every statement that Ms. Hurst provided after she was originally detained should have been suppressed. As counsel states, there is nothing in the record. What is contained in the record is that the arrest warrants were issued. A bond was granted in the criminal court after the criminal court arraignment. Ms. Hurst was in continuous custody from the moment she was placed in the back of that car across the line of the Commonwealth of Kentucky until, I want to say, May the 16th or May of 2016, some 6 months later. We would respectfully request that this honorable court reverse the convictions that had by Ms. Hurst and allow her to be tried on the evidence that is admissible. Thank you, Your Honor.
All right, thank you, sir. That concludes this argument.
This honorable court is now in recess until 2 p.m.